Well, one of the reasons why a person or persons decides to either incorporate or they decide to set up an LLC is to avoid, there are other reasons such as taxes and things like that. The biggest reason is to avoid personal liability. When I very first started practicing in the state of Florida, I was in front of a judge and we were trying to what's called pierce the corporate veil. So in other words, you say, well, there's a corporation that's actually in place, just like an LLC. When in the corporation, you follow the articles of incorporation, and the LLC is articles of organization, and that gives you a formal kind of status as a business organization. However, if you don't act like a corporation or act like an LLC, then someone could try and hold you personally responsible by what's called piercing the corporate veil. And I remember I was in front of this judge, and the judge is like, this isn't New York City. This is why people incorporate in the state of Florida. So it's a pretty high standard, and I think that kind of reaction with judges is fairly standard in the state of Florida, is that it's a fairly business-friendly state. Now, you know, if a business owner gets sued successfully, they would argue that it's not business-friendly. But all in all, if you look at it with other states, fairly business-friendly. And insofar as that, it means that it's difficult to pierce the corporate veil and to hold somebody personally liable when they're acting within the scope of the organization. The key is that person acting under the scope of the corporation or the LLC. And one of the things is you may have in your operating agreement or your bylaws of your corporation that you're going to have a meeting with the board of directors that's set up, and in that meeting, or with the managing member and the other members, and you're supposed to hold that meeting per the governing documents of that business entity, and you don't hold the meetings. Or when you're signing stuff, you don't sign it as the managing member of the LLC. You don't sign it as the president of the corporation. Then there's an argument to be made that, well, they're not acting as a business entity, they're acting as individuals, because look at how they sign these documents. Seems kind of silly, but that is actually how things work. So when I set up business organizations for people and I say, look, one of the reasons we're setting this up is to limit your exposure to personal liability, but you have to act like you're a corporation. And in the state of Florida, you can be an LLC with one person. You can be a corporation for one person, at least if it's a for-profit corporation. If it's not for profit in the state of Florida, then you have to have 3 members for the board of directors as opposed to 1 for a corporation, but if it's, or for a for-profit corporation. But if it's a for-profit corporation or if it's an LLC, then you can have one person that is basically wears all the hats, but you still have to act like you're a business organization. So you have to have your meetings, you have to sign that way. Now, the other thing that some people that, especially people that are relatively new in business, that they may not understand is that all that's well and good, but there may be vendors, there may be people that are renting you office space or warehouse space, there may be vendors where you need supplies from. Those vendors may in fact actually contract with you as the LLC, and that's it. And as long as you're acting as the LLC or the corporation, you're fine. There's no personal responsibility if you breach that contract, just the responsibility of the business entity. However, a lot of vendors and a lot of landlords that have commercial businesses, commercial centers or warehouses, things of that nature, may, especially if the LLC is relatively new, or if if it's relatively small in nature and doesn't have a long track record, then they may ask the person that is the managing member, the 100% member shareholder or interest holder, I should say, or in a corporation, the shareholder may ask those persons to sign personal guarantees or indemnification. So then that person would be personally responsible under that particular contract. Not under everything that happens, but under that particular contract, if they say, we're not going to deal with you and you really need to deal with that person. So you sign a personal guarantee and you default. You can't come back later and go, oh, well, I have the protection of the LLC, of the corporation. They're just going to say, yeah, you do, except you sign that personal guarantee. So whatever's in that personal guarantee, that applies just like any other contract would. So it's not black and white, but that is one of the biggest reasons why people do incorporate and organize an LLC legally with the state, is to limit personal exposure from liability.